I'll go ahead and get started. Again, good afternoon, everyone. Welcome to our Toolbox Tuesday session on the California Environmental Quality Act and SCAG's roles under the state law. I'm Annalie Ekman. I'm an associate regional planner with the Environmental Analysis Business Unit here at SCAG. And I'm co-presenting today with my colleagues Li-Jin Sun and Karen Calderon, who will introduce themselves during their presentation. To start, we have a few housekeeping items for the session. This meeting will last a maximum of 1.5 hours. It'll be recorded, and by continuing to attend this meeting, you consent to being recorded. All participant lines will be muted during the presentations, and we welcome everyone to voice questions during the Q&A sessions that will happen after each presentation. If you have a question during the presentation, you are also welcome to type it in the chat and use the raise hand function. We'll get to those during the Q&A sessions. A recording of the webinar and PowerPoint slides will be made available on the SCAG website and sent to everyone who has registered for the event. CEQA is a big topic in California, and we understand the importance of information sharing and learning. This presentation is meant to share general information about CEQA and is to be used as a basis for discussion and learning. Also, we at SCAG acknowledge that we are living, working, recreating, and taking space on stolen Indigenous land. SCAG's LA office sits, and I'm currently sitting on the land of the Chumash, Tongva, and Kizh people. We recognize that the tribes are still here, and we are committed to lifting up their stories, cultures, and communities. This presentation describes ways in which CEQA approaches special consultation of tribal governments, but I also want to mention that this is just one of the many topics that SCAG aims to engage with our tribal community members on in the near future. So we welcome you to explore the resources that I'm about to provide in the chat to further awareness of Indigenous communities. There we go. Okay, we'll start off today's session with an overview of CEQA Basics, and then we'll provide details on how SCAG applies CEQA through the Intergovernmental Review Program and the Program Environmental Impact Report for Connect SoCal 2024. And with that, I'll hand it over to Li-Jin.
Thank you, Annalie. Good afternoon. My name is Li-Jin Sun. I'm Program Manager with SCAG Planning Division. I will lead today's presentation and go over the basics of CEQA. CEQA has been with us for over 5 decades, but in the 60s, CEQA did not exist. The movement started in the mid-last century. Many of you may have read or know about the book called Silent Spring. It's a fantastic environmental science book that documented the detrimental effects on the environment from the use of pesticides. And also in the late 60s, just north of us, there's a Santa Barbara oil spill. These events really, and many other environmental movement events, led to the 2 prominent environmental regulations. At the federal level, we have the National Environmental Policy Act, which was signed in 1969. A year later, in 1970, the California version, the California Environmental Quality Act, was signed into the law. 5 decades later, NEPA, particularly CEQA in the state of California, are still very much influencing how environmental decisions are made and the public processes by which those decisions are made. I have a technical glitch. Bear with me for a second. Okay. Before talking about CEQA, I'd like to provide a very high level of overview of basics of NEPA. NEPA, the National Environmental Policy Act, is the federal equivalent of CEQA. A proposed project in California can sometimes trigger both CEQA and the NEPA. When a project in California is carried out, funded, or needs approval in whole or in part by a federal agency, NEPA is triggered. You may be familiar with CEQA document types. NEPA documents have a slightly different naming conventions, but it's similar to CEQA in terms of using the level of significance to determine the appropriate NEPA document. Under NEPA, we have environmental assessment, which is the initial study under CEQA. We also have environmental impact statement. Under CEQA, we have something you are very familiar with, EIR, the Environmental Impact Report. Under NEPA, we have findings of no significant impact. The shorthand is FONSI, and that's a NEPA decision document that describes why a project will have no or any environmental significant impact. And this determination is based on the analysis contained in the environmental assessment. CEQA is just one of the planning and or environmental requirements. One of the CEQA policy is to have a better alignment and integration with other environmental review requirements, such as NEPA. So this is an important policy to keep in mind. When a proposed project or a governmental action in California triggers both CEQA and the NEPA, the preparation of environment documents to comply with both requirements is required. Okay, moving on to next slide. Okay, all right. The next 20 so slides will focus on the CEQA Basics. CEQA became the law in 1970 in the state. Is codified in the Public Resource Code, PRC. Sometimes an environment document you have reviewed or prepared makes a references to a CEQA guideline sections. CEQA guidelines are developed by the Governor's Office of Planning and Research, OPR. They implement the Public Resource Code. From time to time, the OPR reviews and makes recommendations for amendments to the CEQA guidelines. And the most recently updated CEQA guidelines became effective in December 2018. CEQA is often referred to as a disclosure requirement. Let me see. Sorry, I'm gonna move back a slide. Okay. I'm having a little technical difficulty here. Okay. Sorry about that. Okay, here we go. CEQA often is referred to as a disclosure requirement. It informs the government decision maker and the public of the potential environmental impacts, identifies, discloses significant environmental impacts of a project or governmental action by the lead agency. If the impact is found to be significant, then mitigation measures, feasible mitigation measures to reduce or avoid those significant adverse environmental impacts are required, or consider some alternative to the proposed project or governmental action. The purpose of those alternatives is also to avoid or reduce significant adverse environmental impacts. At the end, a project can still move forward despite its significant adverse unavoidable impacts because at the end of the day, CEQA requires the decision maker to balance with other the project's other benefits. And those benefits will sometimes overcome the project negative environmental impacts so that a project can still move forward. So at the end of the day, the decision maker had to balance the project negative, adverse, unavoidable environmental impacts against the potential social economic benefits of the project. Okay, I'm trying to click again. Sorry. Okay, too much. All right. CEQA does not require a right decision. I'm going to read a few excerpts from the courts of the state and that declare several policies that are implicit in the CEQA. For example, CEQA is intended to be interpreted in such a manner as to afford the fullest possible protection to the environment within the reasonable scope of statutory language. CEQA is not to generate paper, but to compel government at all levels to make decisions with environmental consequences in mind. CEQA requires the decision be informed and balanced. The CEQA Lead Agency's determination shall be final and conclusive unless challenged. CEQA must not be subverted into an instrument for the oppression and the delay of social, economic, or recreational development or advancement. This slide, just a second. I'm trying to see if I can get some help on moving the slides.
Yeah, just let me know. I'll keep forward.
Okay, sounds good. Thank you. This slide shows a detailed SQL development process chart. I'm not going to go over all of them. It's really small, but if you want to check it out, the link is included on the slide. But I'm going to highlight 5 decisional steps in the following presentation. Next slide, please. Okay, thank you. The first decisional point is to characterize the nature of what's in front of a public agency. Is this a project within the meaning of CEQA? CEQA defines the project very, very broadly. Governmental action is subject to CEQA if the action is, if the activity is undertaken by the government, the activity needs a financial support or some sort of approval from the government. A private action is also subject to CEQA if it involves governmental participation, financing, or approval. Next slide. Where a government agency can use a judgment in deciding whether and how to carry out a project or action, that decision is, that agency has a judgmental control and discretion over the action of project. And this is something that you have heard the terminology called discretionary project. In contrary, where the law requires a government agency to act on a project in a set way without allowing the agency to use its own judgment or control, the project is called ministerial and the CEQA does not apply. CEQA also applies to a public agency's own action unless it's exempt. For example, a SCAG long-range transportation plan and a sustainable communities strategy, RTP SES, is an action that SCAG regional council considers and approves, and it's a CEQA project. Later in this presentation, my colleague Karen will go over the environmental review process for the upcoming proposed 2024 RTP and SES. Next slide. Thank you. After determining that a project is subject to CEQA requirements, the second decisional step is to determine if it can be exempt from the requirement to conduct further CEQA analysis or to prepare an EIR, NEC-DEC, or mitigating NEC-DEC. There are various types of exemptions. Some are declared by our lawmakers. Some are due to the nature of the project or governmental action, for example, being very small or involving very minor alteration to the physical environment. Some are just based on common sense. There are 2 things I'd like to point out from this slide. One is, in order for a categorical exemption to apply, exception to the exemption must not apply. The second is, when a CEQA lead agency determines that a project is exempt from CEQA, it is recommended, though not required, that it determines whether it will perform the filing of the notice of exemption. Again, such a filing of notice exemption is not required in the CEQA, but oftentimes may be recommended as something prudent to do in order to lock in the statute limitation. Again, statute limitation is something I will go over in the later presentation. Next slide, please. If a project is exempt, then you're done. If a project is not exempt, the next step is to determine what is the appropriate level of environmental review and the CEQA document. That will lead us to the next step, step 3. Next slide, please. Thank you. In general, initial study is the environmental analysis of the topics listed in CEQA guidelines Appendix G. Initial studies are typically used to identify potentially significant environmental issues, and also is used to help narrow down the scope of the EIRs. The environmental analysis in the initial study provides substantial evidence to support that a negative declaration or a mitigated negative declaration is an appropriate CEQA document, or an environment impact report will be warranted. Next slide, please. Thank you. The results of the environmental analysis in initial study indicate the level of significance for each of the environmental topic areas. Right now, we have 20 topics under CEQA that includes tribal cultural resource under AB 52 requirements and a wildfire. And the lead agency uses the information and the conclusion from the initial study to determine the appropriate CEQA document and notices for the proposed project. A negative declaration is prepared when all 20 topics are found to have no impact or the impact is less than significant without the need to incorporate any mitigation measures. When at least one of the 20 topics is found to be significant, but can be reduced to less than significant after incorporation of mitigation measures, a mitigated negative declaration is prepared. When at least one of the 20 topics is found to be significant, but cannot be mitigated to less than significant even after the mitigation are incorporated, then an EIR needs to be prepared. Next slide, please. Thank you. This slide shows different types of EIRs you probably have seen, reviewed, or prepared yourself. The one type of EIR that I like to highlight is program EIR, and then the program EIR is what we are going to prepare for the proposed 2024 RTP SES. My colleague Karen is going to go over that. Another thing I want to point out on this slide is even though there are different types of EIRs, there are really no different CEQA requirements. For example, there's no set of CEQA requirements for project EIR, and the versus there's another set of CEQA requirements for the master EIR. They're just one set of requirements for all types of EIRs. Next slide, please. The fourth decisional step is to determine what is the agency role. In practice, this question seems very easy. A lot of times, many agencies already know they are the CEQA lead agency before or at the same time, they know what level of CEQA analysis a project or action is needed. But sometimes this question is not that clear. There are three roles for the agency to take on under CEQA: lead agency, public commenting agency, or responsible agency. Like I mentioned earlier, SCAG is the CEQA lead agency for its RTP and SES because it has the greatest responsibility for developing and approving the RTP and SES. What I would like to note is that sometimes an agency can be a public commenting agency as well as a CEQA responsible agency for the same proposed project. For example, the local air district. It can be its own CEQA lead agency for its rules, regulations, or air quality management plan. The local air district is also serving as a public commenting agency, providing comments on other agency CEQA documents, air quality analyses. The same local air district is also a CEQA responsible agency for the issuance of air permits for the projects. Next slide, please. In addition to, next slide, please. Thank you. I had the same small delay. Thank you. In addition to being a CEQA lead agency, SCAG is also a public commenting agency through its Intergovernmental Review Program, IGR. Later in the presentation, my colleague Anna Lee will go over the SCAG's IGR program. Next slide, please. Thank you. After a public agency determines the appropriate CEQA document and what role it must undertake for a proposed project, the last and the fifth decisional point is to prepare the CEQA document. and subject the document to the appropriate SQL noticing requirement and the public review process. The next 4 slides from slide 22 through slide 25 are really content heavy, includes a detailed discussion on SQL notice requirement and the public review process. In the interest of time, I'm going to skip those materials, but you're free to read them after the presentation. But there are 2 things I'd like to highlight. The first is, depending on the SQL document, the SQL requirement for notices and public review process may differ. The second thing I'd like to point out is a lead agency may choose, and I want to emphasize those words, may choose to go above and beyond the SQL public review requirements. For example, negative declaration and a mitigated declaration is only required to be circulated for a minimum 20 days. In practice, many lead agencies choose to circulate the document for 30 days of public review. Another example is a draft EIR is also required to be circulated for a minimum 45 days. Again, many lead agencies chose to circulate the draft EIR for sometimes 60 days or even 90 days. Next slide, please. I'm going to skip all the way to slide 27. Perfect. Thank you. This slide includes contents of a typical draft EIR, their typical order and typical flow. The reason I emphasize the word typical is the order and that the flow is not required in the SQL, and they're not set in stone. However, this is a ordinary, the regular flow that you typically will see in the EIR, because just like any other reports, the beginning of the draft EIR will have a table of contents, will quickly summarize the components of project, what are the SQL guiding requirements for the draft EIR, what are other agencies' roles and who are they, and what is the lead agency role. And those will be discussed in the executive summary as well as in the introduction. And before a lead agency analyzes a project environment impacts, the lead agency has to tell the public and decision makers what is the project, what are the components, what are the processes, and that discussion is included in the project description chapter. Next slide, please. Thank you. The environmental analysis would typically start with a description of existing conditions. And this is really important discussion because it describes the conditions on the ground without the project. And then when you impose the proposed project onto the conditions it currently existing on the ground, that net difference or the delta is your project's environmental impacts. And also in the draft EIR, it analyzes a project's 3 kinds of impacts: direct impacts, indirect impacts, and accumulative impacts on the environment. After the impact analysis is completed and the results show that the impact are potentially significant, then mitigation measures and alternatives are needed to see if the impacts can be reduced to less than significant. Next slide. Thank you. As we have gone over the major decisional points, I'd like to point out the importance of the SQL process, which are really closely correlated with some of the SQL principles that I highlighted earlier in the presentation. There are 2 kinds or 2 categories of SQL requirements: the substantive requirements and the procedural requirements. The earlier presentation thus far primarily covers the substantive requirements. What I want to highlight through this slide is more on the procedural, on the process of the SQL requirements. One of the basic SQL principles is good faith effort, disclosure. A court does not pass upon the correctness of an EIR's environmental conclusions, but only determines if an EIR is sufficient as an informational document and to provide meaningful public participation and informed decision-making. When other laws applied, integrate SQL requirements as much as you can with other environmental review and consultation requirements, such as NEPA, if NEPA is triggered, as well as with tribal consultation requirements under AB 52. And then the correlation and integration is really help to reduce delays in the paperwork and also to streamline the multiple complicated environmental review process that's needed for the proposed project. Lastly, the appropriate public review duration may differ. Like I said earlier, it really depends on what type of CEQA document is needed and appropriate for your proposed project. CEQA includes 30 days or 45 days in the requirements, but remember those are minimum requirements, meaning you as a lead agency may choose to do more for public engagement and outreach during the project CEQA process. Next slide, please. Thank you. Statute of limitations, I mentioned that earlier. It's basically a time window, a time period within which a legal challenge to a lead agency decision or action under CEQA is brought. Depending on whether or not a CEQA notice is filed, duration for that time period differs. In general, as you can see from this slide, in general, if a CEQA notice is properly filed, the time window for bringing a legal challenge is very, very short. It's either 30 days if it's an NOD properly filed. If an NOE that has been properly filed, the statute of limitation only affords 35 days. Next slide. Thank you. This is really the last slide of the first portion of CEQA Basics. What I want to show with this slide is that the latest 2022 CEQA guidelines version is available for free download on AEP's website, and that website link is included on the bottom of the slide. Another thing to know is each year AEP publishes a newer version. In general, from version to another version, the questions don't change. The CEQA requirements also don't change much unless there's a new requirement that's being codified, incorporated into the guidelines. But what's really good about the newest version each year is the beginning of the book provides a really detailed and high-level summary of the most recent case laws, CEQA case law that occurred in the previous calendar year. So that's why that's another reason to stay on top of those CEQA guidelines and the case laws if you're interested and helpful in your CEQA preparation and decision-making process. Next slide. Is that a time we are going to have some fun? Or are we going to do questions first?
We have questions first.
Okay, we do questions first before we have some fun.
Yeah, so if anyone has any questions for Leighton on this presentation, you can raise your hand, you can throw them in the chat. Yeah. Oh, it looks like we have a raised hand. Judy, do you check?
Yes, thank you. I had a quick, now, if this is a premature question because you're not far enough into the presentation, excuse me for that. It may be like the second half, but I have found tremendous confusion going on with the cities and the counties on cumulative impact assessment. And for example, if you took the new logistics centers coming into the county of Riverside, the county of San Bernardino, by nature, the really heavy activity of new projects, I think they've had something like 200 million square feet of warehousing put in 4 or 5 years. So the Department of Justice has submitted some information questioning whether the cumulative impact assessment is capturing the full greenhouse gas effect. And I'm having trouble finding anybody to give me a simple explanation of what that assessment process really should be. Can you help with that at all?
I can provide you, well, first of all, thank you for the really good question. Cumulative impacts is one of the toughest topics in CEQA. without the specifics, it's hard to say, but there are a couple of resources that I think I might be able to help you out and point you to. One is I'm aware the local air district has started its public process for providing updates to their own CEQA guidelines on cumulative impacts, particularly focusing on air toxics. So I'm not sure if you're aware of that. If you're not, it might be really good resources to check out and then connect with them.
Yes, thank you. To some extent, and the biggest problem I'm having is the biggest requirement I found for CEQA, because it's so much for the public, it's that the assessments have to be in plain English, and even the experts can't understand their own greenhouse gas assessment. And I don't know, in terms of the plain English rule, which is coming from every level of court intervention, is that the public must understand the assessment, and it needs to be in plain English. Have you ran across, in dealing with the general public, one of the primary concerns I get is the obscurity of the technical reports. They simply are really not written for public consumption. And greenhouse gas seems to be the biggest offender in that respect. And even the Department of Justice and the courts of law are complaining about it. So I didn't know if you had a comment for that.
That's a really good observation. I mean, like you pointed out, like, for example, a typical EIR, you have 1,000 pages, 2,000 pages. That in itself is really daunting to go over and to go through, especially if EIR is only circulated for 45 days. It's actually not a lot of time. And especially a lot of time the EIRs is circulated or released right before the holiday season. So these are the things that we have noticed. But as a CEQA lead agency for our own projects, those are the things we try to avoid. But as for other lead agencies, we can speak for them.
Thank you so much.
Thank you.
We also have a hand up from Susan Herberton. Susan, would you like to unmute and voice your question?
Okay. Hi, can you hear me?
Oh, hi.
Yeah, hi. My name's Jose Mendeval, and Susan Herbertson is my supervisor. I have a question. So when you say properly, okay, so we have the 35 days and the 30 days. I also, and versus 180 days. I assume that either the NOE is filed within 5 days or the NOD is filed within 5 days to ensure the 30 or 35 days, depending on whether it's a categorically exempt or it's something else. Is that 5 calendar days or 5 working days? And how does that work?
I think the CEQA guideline just said 5 days, doesn't say calendar or working days, but we can check on it and get back to you. And then, but I believe it's 5 days.
So you mean 5 calendar days?
Yes, but we will have to check on that and to confirm.
So if you have an action that's taken by the planning commission on a Wednesday, and a lot of the cities have short weeks where the Friday's off, you would have to make sure that the next day that NOD or NOE was filed, is what you're saying.
Yeah, but you can also file on the Thursday, the day after.
Right.
Yeah. Mm-hmm.
Okay, thank you.
Mm-hmm.
Thanks, Jose. Any other questions? Great thoughts. If not, we can move on to a pop quiz. This is a really low stakes way to test your knowledge and see if you're paying attention. Or maybe you just know all of this already and you could just, sweep by this. We have 5 questions. This is anonymous. We're not going to take, your scores or anything, but just a way to test your knowledge. So Legia, do you want to go ahead the first question?
Sure. Next slide, please. Oh, yeah, sorry. Okay. So first question, true or false? Every project in California requires CEQA review. A lot of activities. There's really, okay, one couple things to say is there's only one most correct answer. All right, end the poll. Okay, I'm gonna show the results. The answer is, let me see. Can I move on to the next slide? False. Not every project in California requires CEQA review. For example, like I mentioned, if a project only requires a government agency to act in set way, they cannot deviate from, they have no room to exercise any judgment, then it's ministerial. And then ministerial project is not subject to CEQA. It does not require CEQA review. Okay. Next question. Open the poll, please. The question is, when would a project need to comply with the California Environmental Quality Act? When an environmental impact report has to be prepared, if a project requires a discretionary determination, or if the project will have significant impact, or if a project needs to be LEED certified. Thank you. Maybe 10 more seconds. Okay, we close the poll. I'm going to share the results. The correct answer is a project requires a discretionary determination. I see the most selected choice is a project is discretion determination is required. So that's the correct answer. The second highest is that the project will have significant adverse impact. That is actually not a quite correct answer, because you are not going to know if a project has significant or less than significant impact unless the project is subject to a CEQA requirement, has already gone through some sort of environment analysis, oftentimes contained in the initial study, to tell you if the project will have significant impact or not. So therefore, among the four choices, choice number 2, a project requires a discretionary determination, is the most correct answer to this question. Open the poll for the next question. Can we open the poll on this question?
Yeah, it's up.
Okay. Oh, I'm not able to see the poll. Sorry.
We have 65%.
Okay. All right, so I'm going to just go over the question. Which entity is primarily responsible for a project environment review? Is the state the most correct answer is the last one, a lead agency. It could be state agency, regional agency, local public agency, or a joint powers or school districts. So that's the most correct answer to this question. Next question. Okay, which of the following is not a CEQA document? Open a poll, please.
I think people are really convinced of this one.
This one is, we get 100% accuracy rate. Great job, everyone. The correct, the question is, which of the following is not a CEQA document? I think we can end the poll. Convincingly, local ordinance is not a CEQA document. Local ordinance can sometimes to be included as the CEQA packet, but it's not a CEQA document. I think we have one more question left. Okay, last question, open a poll, true or false? A project has to have no impact or a less than significant impact before it can move forward. In other words, if a project has a significant impact, it has to be all reduced to less than significant before it can be moved forward. It's very interesting. You see the bars slowly moving, slowly decreasing. I think we can close the poll. So the correct answer is false. A project can still move forward despite its significant unavoidable adverse environmental impacts. A type of CEQA document that I didn't specifically mention in my presentation, it's called a statement of overriding consideration. This is a document where the lead agency may choose to describe and discuss the project's significant adverse impact in light of the project potential benefits. For example, job benefits, economic benefits, social benefits. And when those other non-environmental benefits outweigh the project negative environmental impacts, a project can still move forward. Okay. Most of you got this question correct. I think that pretty much concludes the poll of fun times. And then that will lead us to our second portion of the presentation on SCAG's IGR program. I'm going to turn the space to Annalee. Annalee, go ahead.
Thanks, Lee-Jin. Before we move on, though, we had a couple of people in the chat reach out to us that the question about the 5 days, calendar days versus working days, at least I can find in regards to the notice of determination, it is 5 working days. So just to clarify that. But yeah, Annalee Ekman again here. I manage the Intergovernmental Review Program, also just referred to as IGR. And I have a quick, simple overview of what we do in the IGR program, which is mainly 2 functions. So the first is a clearinghouse function. I might have a small delay here too, hold on. There we go. So clearinghouse function, pursuant to Federal Executive Order 12372, SCAG is the regional clearinghouse responsible for the review of federal grant applications, federally required state plans, federal development activities, and federal environmental documents. So this has nothing to do with CEQA, even though we're talking about CEQA. When we receive these requests, we log and write acknowledgement letters within 2 weeks of receipt so that the agency or organization can continue in their process. So this is, again, a rather small part of our role, not related to CEQA. The second role is the commenting function. And the slide will update in a second, which is more relevant to our presentation. So this might not be a well-known function, but per CEQA guidelines, lead agencies must submit their environmental documents to affected state and MPO agencies for review and comment. SCAG provides resources via comment letters to projects that are considered regionally significant per CEQA guidelines. CEQA has specific project types and size thresholds for what is considered a regionally significant project, and those are defined in the guidelines section 15206. And just as an example of a regionally significant project, it could be a residential development with over 500 dwelling units. Another example is a local general plan, element, or amendment. Going on to the next slide. So every time SCAG receives a CEQA notice, we log it into our IGR database. This is an internal tool where we can keep project information like the title, location, intensity, state clearinghouse number up to date every time we receive a new notice for each project. because we understand some of the project information might change, especially for a large project preparing an environmental impact report between the notice of preparation and the notice of availability. So we try to keep everything as up to date as possible. And the information saved in the IGR database is then shared publicly via the mapping tool. So the mapping tool is accessible right now on the SCAG website. You can use the link on the slide to get there. The mapping tool shows projects that result in physical development for all projects in the SCAG region that we receive CEQA notices for. So it's a good way to see what projects are potentially coming up. Just note that it's a complete data set of every notice that we've received, over the past 10+ years. So you might need to do some filtering with the years. And also understanding that projects in the environmental phase are not guaranteed to be built. SCAG's growth forecasting team uses IGR data to explore potential for changes in future growth patterns. We focus on the largest projects that we receive in a given period of time, typically like a 5-year period. And basically this database helps SCAG verify our modeling efforts. IGR also publishes a couple of reports. The bi-monthly report is on the SCAG website. It includes a detailed list of all the notices that we receive over a 2-month period. This is to fill the first clearinghouse function, but we include all of the CEQA notices that we receive too. The second report we develop is the annual clearinghouse report, which is a summary of notices received throughout the year. And that is sent to Caltrans as a final work product. So it's more of a performance measure of the IGR program. So if you are from a local agency or work with local agencies on CEQA filings, please know that you can submit notices for environmental documents to SCAG through our online form or email them directly to the IGR email on the slide. Every notice we receive helps us develop a better understanding of development patterns and expected growth in our region. So I highly encourage you to check with your agency, make sure you're sending CEQA notices to SCAG, especially for those regionally significant projects. Just check if our email is on your distribution list. And that's a little taste of the IGR program. I'm happy to take any questions now. Judy, I see your hand up.
Sorry about that. Thank you. I noticed that in the original slide that most of what you had noted was federal level. And then I was less clear on whether you monitor at the state level for regionally significant. And if you don't, who does? Is there an agency that's doing the counterpart of what you do for state regionally significant issues?
Mm-hmm. Yeah, so I tried to separate the two functions of IGR, but that first slide that I had, that the clearinghouse function for IGR, that is all the federal plans and environmental documents. That's just one aspect. SCAG does review regionally significant projects per CEQA, so per the state guidelines, we do review those projects. I hope that answers your question.
Well, and it goes back to my original question earlier today, that there's a series of communications between the State Department of Justice and the counties of Riverside and San Bernardino on warehousing projects, with a commentary that the cumulative assessment does not seem to conform to the governor's guidelines for greenhouse gas reduction over time. So under your role of IGR, is that something SCAG would take a look at? Do you have any role in the IGR context?
We definitely pay close attention to warehouse projects. I think SCAG has done a good job of trying to collect information about warehousing and goods movement projects. the IGR program works closely with our subject matter experts in our transportation team. So every goods movement project that we receive a environmental notice for gets sent to our goods movement team, who are monitoring development and especially in the IE and working on goods movement regional coordination projects. So that's not a role specific to my role in IGR, but yes, we are monitoring the goods movement development of goods movement projects.
Is there a contact person or a contact department where I could get more information?
Sure, yeah, I can put you in touch with someone in our goods movement group. Yeah.
Oh, wonderful. Even if you could write that in the chat box.
Yes, I will.
Thank you so much.
Great. And I think, Jose, I think that's your hand up too.
Yes, it is. Hi.
Okay.
Couple of questions. On the regionally significant projects that when local governments send that to SCAG, is that part of the variable? Is that one of the variables you use when you're determining RTIP and RENA? That's one question. And two, the last slide that you showed for the filing of environmental notices to SCAG, is that for should we be doing that for all projects, even if they're not regionally significant, or are you only interested in the regionally significant ones?
Sure. Great questions. I might throw the first question over to Legion if you can help with that. As to the submitting environmental documents to SCAG, the CEQA guidelines ask you to submit those for regionally significant projects only. So that's the only, I guess, requirement. But if you send other projects and you want to be, safe and send all of the projects, we're also okay with that. But yeah, it's really meant for regionally significant projects. To your first question about, can you repeat? You want to see a connection between RENA and the program?
Yeah. So when you describe what's a regionally significant project, I think an example was like 500 units, and that's significant. So when you, for example, in say Culver City submitted 3 projects over in the last RENA cycle, as an example, that were 500, 600, and 700 units. So they were regionally significant. Would that be a factor that you would use in the next RENA cycle in determining RENA numbers for Culver City in this hypothetical? In other words, would you use it as do you use the regionally significant projects as a barometer, if you will, for expected growth over our tip cycle?
I don't think none of us here is the RENA expert. So
I can jump in on this, Legion, if you'd like.
Yeah, Kevin, would you? But
Sure.
I do want to, Kevin, before you start, I'm going to say is, regardless what the RENA requirements, even if the project, the quota that you enter for RENA purposes, if they are going to go through the entitlement process, they will probably have to go through some sort of CEQA. And then the regional significant definition that Annalie mentioned is really for CEQA purposes.
Okay.
So Kevin, please.
Yeah, I would say it's to a slight degree perhaps, but it's a very indirect process. We use IGR, the data to some degree in the initial stages of developing a typical RTP SCS forecast. But ultimately, there are a lot of factors from the top level demographic and economic drivers of growth to the other land use considerations on the ground. And ultimately, we put this out to local jurisdictions separately, and the process for that is going on right now. Deadline is December 2nd for this next plan. Just another shout out to that. And ultimately, to your question about RENA, RENA happens every other RTP SCS cycle. It's not happening for this one currently. And the manner in which an RTP growth forecast becomes a piece of the RENA allocation can differ each RENA cycle. And it is different based on state law, priorities, what the regional council ultimately decides. It's certainly not a one-to-one relationship. So to some degree, there could be a relationship between a project that shows up in IGR for review and subsequent arena, but that's a very, I think there are a lot of moving pieces in the middle of that as well.
Okay, thank you. Thank you very much.
Thanks, Kevin. Glad you're here. Awesome. So any other questions? Also, a shout out to, if you haven't checked the chat, Tom Vo from our LDX team is encouraging everyone to schedule a meeting if you haven't already. All right, I think we'll go ahead and move on to our next presentation with Karen Calderon.
Good afternoon, everyone. My name is Karen Calderon. I'm a senior associate planner and the project manager for the Connect SoCal 2024 PEIR that just kicked off yesterday. So my goal for this presentation is to dive a little deeper on SCAG's role as a lead agency in preparing the PEIR for the 2020 to 2050 Regional Transportation Plan and Sustainable Community Strategy, also known as Connect SoCal 2024. So I'm going to provide a bit of an overview of our PEIR process, the basic contents of a typical Connect SoCal PEIR, and inform you of ways that you can participate in the development of our PEIR. Okay. So as lead agency, SCAG is required to evaluate and disclose potential environmental impacts that could come about from implementation of Connect SoCal 2024. Based on SCAG's preliminary evaluation, that's really based on previous RTP-SESs and their associated PEIRs, we anticipate that the upcoming Connect SoCal will have similar environmental impacts that are similar in magnitude as those from previous plans. So therefore, as a lead agency, we determined that an EIR is the appropriate CEQA document for Connect SoCal 2024. Additionally, given the regional level of analysis provided in an RTP-SES, which is pretty much necessary for such a large geographic area, and we have a minimum of a 20-year horizon period. So we determined that a program EIR was the appropriate type of EIR for Connect SoCal 2024. So our program EIR does provide a region-wide environmental assessment, and this is a little bit different from a regular EIR in that our analysis is a lot more high level and is cumulative in nature. Our PEIR is what's called a first-tier environmental document, and that can provide a foundation for subsequent or site-specific environmental reviews that may be conducted by lead agencies for subsequent individual transportation and development projects that are included in our plan. It can also help streamline the CEQA process for qualifying infill projects for specifically per SB 375 and others. So the CEQA process formally kicks off with the release of a notice of preparation, and that's what we call an NOP. CEQA has a lot of acronyms. So an NOP is a type of CEQA notice that informs all interested parties that a draft PEIR will be prepared. This initiates a 30-day public review and comment period where stakeholders and the public can send comments on the scope of the PEIR, let us know the type of environmental issues they're most interested in and would like to see evaluated in our draft EIR. For the Connect SoCal 2024 PEIR, we received authorization to release the NOP for October 17th, which was yesterday. So that began our 30-day scoping comment period, which will end on November 16th, and we are currently seeking feedback on the scope and content of our draft PEIR. CEQA also requires that at least one scoping meeting be held during the comment period, and I will share information on how you can join our scoping meetings at the end of this presentation. So after we receive the initial public input, we're going to begin the preparation of the draft EIR in accordance to the CEQA guidelines. And just like any EIR, our PEIR will be broken up into two parts. There's a draft PEIR and a final PEIR. And the preliminary contents of an EIR based on our previous EIRs is shown on the screen. So the draft really contains the bulk of the environmental analysis. This contains the 20 issue areas that are required by CEQA for us to analyze. It'll have your mitigation measures, alternatives to the projects, cumulative analysis. All of that's going to be in the draft. Once the draft is complete, it's going to go out for public review for a minimum of 45 days. And then we begin preparation of the final EIR. So the final EIR is really the place where we will revise, correct, and finalize the draft based on public and stakeholder input. This is not a separate document, but more of a continuation of the draft. It'll include response to comments, any corrections and additions to the draft are usually laid out and strike out and underline. And then we also typically release this with a mitigation monitoring and reporting program, which will have a finalized version of all the mitigation measures, findings of fact, and statement of overriding considerations. I want to spend a little bit more time going over the environmental issues and topics that we include in the draft PEIR, because this is really the meat of the environmental analysis. Okay. So the environmental analysis chapter is broken up into 20 different sections, and these are based on the CEQA guidelines. These are not topics that we choose. They're outlined for us in Appendix G of the CEQA guidelines. So each topic has its own list of specific questions and thresholds that we evaluate to determine if the plan would potentially have a significant impact to this issue area. So I'm going to go over aesthetics just as an example, so you can get a taste of what this document looks like. So on the screen, you see the aesthetic questions from Appendix G in the CEQA guidelines. And we answer each of the questions that CEQA outlines for each of the issue areas. So for the first one, for example, which is discussing scenic vista, the way we could go about answering this question is by looking at the quantity and types of projects that are included in Connect SoCal and find where they're located, see if we can overlay them against known scenic vistas, and try to estimate the potential short-term and long-term impacts to views that could occur from construction and operations of these projects and other policies included in the plan. And we would do this for each of these questions and then for each of the issue areas. So after we conduct our analysis, we have to determine a level of significance, which is a conclusion of what the environmental impacts are for each of those questions. So there are 4 options that we can choose from, which are shown on the screen. The first 2 are similar. There's either no impact or less than significant impact. So those are impacts that are minimal, negligible, or just do not require mitigation. The next level of significance is less than significant with mitigation measures. So these are potentially significant impacts that have been reduced to less than significant levels through the incorporation of mitigation measures. And then the final level is a significant impact. And these are impacts that would remain significant and unavoidable even after the implementation of all feasible mitigation measures. So we determine the level of significance for each of the CEQA questions to decide whether or not mitigation measures are warranted. So As for all EIRs, CEQA requires that lead agencies mitigate significant impacts through the incorporation of mitigation measures. But SCAG is a little bit different than other lead agencies in that we don't have authority or jurisdiction to implement project level mitigation measures. So how do we comply with this requirement? Our PEIRs have previously included two sets of mitigation measures. We include SCAG mitigation measures and project level mitigation measures. So SCAG mitigation measures are within our authority. These are things we can do as an agency to reduce impacts throughout the regions. For example, we have the power to convene through working groups, share regional data. There's things that we can do to help mitigate some of these regional level impacts. But we also include project level mitigation measures that are intended for specific projects and other lead agencies and developers to implement as applicable and feasible in subsequent environmental review processes. These mitigation measures are optional, and we recognize that the implementation authority lies within local jurisdictions. Another CEQA component required in an EIR is the alternatives analysis. So the idea behind this is to ensure that agencies have taken what's called the hard look at how they can tweak or modify the plan or project to avoid potentially significant environmental impacts, while at the same time achieving most of the project objectives. The four main requirements to the alternative analysis are on the screen. The analysis must include a no project alternative to understand the environmental impacts of not adopting the plan or project. The analysis should also include a range of reasonable alternatives. We want to meet most of the project objectives, and at least one needs to be environmentally superior. For us, because Connect SoCal 2024 is still being developed, it's difficult for us to determine what exactly our alternatives are going to look like at this time. But similar to previous cycles, we are anticipating our analysis might take a bookend approach to provide for that reasonable range required by CEQA. So our left bookend would be the no project alternative, which is again required by CEQA, and that's going to analyze the environmental impacts that we would expect to see if Connect SoCal 2024 was not adopted. And then on the other hand, we would have a right bookend, which would describe the environmental impacts we might expect to see from a more intensified land use pattern. So this would assume more aggressive land use development plan patterns than what would be in the plan. And it would explore what would happen if we maximize growth around HQTAs and urban areas, and then see how that affects the level of significance for each of our environmental impacts. Obviously, we just began our scoping process yesterday, so we're still seeking feedback on these preliminary alternatives, but this is the approach we have in mind for now. So I did want to just give everyone an overview of what the key milestones are for our PEIR process. It's a very long process. It typically takes around 1.5 years. The key takeaway from this slide that I want you to take is that public participation just happens throughout the process. There's 2 official comment periods that are required by CEQA, the 30-day comment period in which we are now. And after the development of the draft, there's another 45-day comment period. But outreach efforts are really ongoing. And we engage with tribes, the public, and stakeholders really throughout the entire process. So one of the ways that we engage is by hosting scoping meetings. So I want to take this opportunity to share that SCAG will be hosting 2 virtual public scoping meetings for our PEIR, both with the same content. And if you're interested in attending or submitting a comment on the NOP, you can do so using the information on the slide. So this really concludes my presentation. I'll be happy to take any questions at this time. And I'll just leave this slide up in case anybody wants to jot anything down.
Again, you can raise your hand or drop questions in the chat if you have any.
Thank you, Judy.
Thanks, Judy.
If there are no questions, I will leave our contact info up on the screen for Legion, Annalie, and myself. If you would like to send any specific questions on Connect SoCal 2024, we have a designated email address for that on this screen. And also, if you would like to submit any CEQA notices to IGR, we have a designated email for that as well. Thank you, everyone, for joining. I believe
thank you.
there's a question. Emily, can you read that?
Yeah, sorry. We have a question from Claudia. It is noted that SCAG plans to be one-on-one with all 197 local jurisdictions to discuss these maps in their local context, provide background on the development of Connect SoCal 2024. Yes, that. Oh, and Moreno Valley has a lot of edits to the zoning there. It's great. I think that's what Tom had dropped in the chat earlier, but maybe Tom, if you're still on, you can drop it again. Yeah, SCAG is meeting one-on-one for the plan with all local jurisdictions. And I think you can schedule a meeting through the link that Tom shared, if you haven't already.
Yeah, thank you for that, Claudia. Sorry if I just wanted to provide some context here.
Sure.
So for jurisdictions within Riverside County, we are working with your sub-regional council of governments. So we're working with WRCOG and also CVAC to schedule one-on-one meetings with you and other local jurisdictions. But that doesn't mean that you are not allowed to review the information. So please go on the SCAG website to look at the data and prepare those comments for us. And once we have the meeting, we can show you how to provide those meetings, corrections and comments into the system.
Great,
Thank you,
thanks for that
Tom.
context, Tom.
So thank you, everyone, for joining. If you have a couple of minutes, please complete our survey to help us improve future Toolbox Tuesdays. We appreciate you spending your afternoon with us, and have a pleasant rest of your afternoon. Thanks, everyone.
Bye-bye.
Thank you to Sarah and Kristen for ASL interpretation. And thank you to Ed for posting our AV support. Thanks, everyone.
Thanks, everyone.